Let us pray. Almighty God, we willingly acknowledge you as the supreme being, most gracious and most merciful. Look down, we beseech you, on us who are members of this Senate, and deign to assist us in the duties that we have to perform on behalf of our beloved country of Trinidad and Tobago. Open our eyes to see the truth and help us to accept it with all its implications into our lives. Direct us, O Lord, in our deliberations, so that setting aside private interests, unwholesome prejudices, and personal affections, we may treat all matters set before us with honesty, courage, and conviction. Through all we say and do in this Senate, may we give glory and honor to your holy name, inspire confidence in our fellow citizens, and make a positive contribution to the peace and prosperity of our nation. Amen.
Petitions, papers.
Leader of Government Business.
Madam President, I have the honor to lay on the table the following paper as listed on the order paper in the name of the Minister of Finance. The annual report of the Financial Intelligence Unit of Trinidad and Tobago for the year ended September 30th, 2019.
Reports from committees. Urgent questions.
Senator Obika.
Thank you, Madam President. To the Minister of Education. Given protests by students of the Point Fortin East Secondary School to highlight infrastructural and administrative issues facing examination preparations at the school, can the Minister indicate what urgent action is being pursued to address said issues?
Thank you very much, Madam President. Madam President, I rise to answer this question on behalf of the government and in particular the Minister of Education. Madam President, following the prohibition notice served to various blocks within the school by the Occupational Health and Safety Authority, OSHA, the Ministry requested a structural inspection from the Ministry of Works and Transport at the Point Fortin East Secondary School. In a letter dated January 24, 2020, the Ministry of Works and Transport stated that the building appeared to be in fair physical condition. In light of this, the Ministry engaged the National Maintenance, Training and Security Company, MTS, to conduct air conditioning, ceiling replacement, and masonry remedial works to the blocks C and D, and an electrical upgrade remedying the defects as outlined by the Electrical Inspectorate. These works are currently 50% completed. In the circumstances, Madam President, every effort has been made to ensure that the students of Point Fortin East Secondary School have access to quality education.
Senator Obika.
This is the flagship secondary school in Point Fortin. Can the Minister indicate when will blocks C and D be complete?
Minister.
I was just informed by the Minister of Education that very likely these works will be completed sometime next week.
Senator Obika.
Madam President, can the Honourable Minister indicate what challenges this has caused or may cause the students completing their school-based assessments?
Sir.
There would have been challenges. The Ministry of Education and the government, by extension, apologizes for the challenges that the students face. But I think once the school is open in the shortest possible time, hopefully by early next week, remedial action will be taken to address the situation.
Next question, Senator Mark.
Thank you, Madam President. To the Minister of Education, further to protests by parents of Poole RC Primary School to highlight the absence of transportation arrangements for their children who are relocated to another school, what immediate action is being taken to resolve this situation?
Leader.
Madam President. Madam President, the Pool RC Primary School was relocated to St. Therese RC School in September of 2019. Sometime after the relocation process, a request was made for transportation to the School Supervisory Division of the Southeastern District. Regrettably, through some miscommunication, this information was not relayed to the ministry's head office at Port of Spain. Madam President, the parents' request for transportation was only officially brought to the School Supervision and Management Division by the principal yesterday. The Ministry of Education is currently in the process of making quick arrangements with PTSE to facilitate the transportation of approximately 6 students within the shortest possible time, and I personally hope by next week.
Senator Mark.
Madam President, can the Honorable Minister indicate whether some 89 students are being affected as a result of the lack of transportation?
But, Minister.
Well, if I'm to believe the Minister of Education and the Ministry of Education, the reply has 60 students have been affected. So that's the official figure.
Senator Mark.
Madam President, or put it another way, when will this situation be rectified as it relates to the provision of transportation? Can you tell us specifically when?
Senator Mark, that was answered by in the original answer that was given to the question. Next question, Senator Thompson, IE.
Given reports that there were 21 confirmed cases of the coronavirus in Hong Kong, including 3 that were transmitted locally meaning within Hong Kong, and students have been returning to this country from Hong Kong, is the ministry considering imposing a quarantine on those students?
Minister of Health.
Thank you very much, Madam President, and I'm grateful for the question. The best way to answer is to read the question. Given reports there are 21 confirmed cases in Hong Kong, the number of cases is actually 15 coming out of WHO. That's one. Including 3 that were transmitted locally, I'm glad for the correction. No cases have been transmitted locally to Trinidad and Tobago. That was the context that I read the question to be, and you clarified what you meant. So no cases have been transmitted locally. And students have been returning to this country from Hong Kong. Is the ministry considering imposing a quarantine on those students? I will now refer to the statement that I read into the Parliament on Friday, 31st January 2020. And I quote, it's on the Hansard and I put it here again. In the event that a person presents at the port of entry in Trinidad and Tobago, they may be subject to quarantine measures. So the answer is yes. Anybody coming into Trinidad and Tobago, whether it's a Trinidad student, anybody, after we announce the travel restriction, will be subject to quarantine. The information I have from the Immigration Department is that 2 students came in 2 weeks ago, and 1 student came in last week before the measures were implemented. My information is, so far, none of these students are symptomatic. But anybody coming into Trinidad and Tobago after the measure will be subject to quarantine and or isolation. So I thank the member for her question. Thank you very much.
Senator Thompson, a supplementary. Yes?
If in fact it's shown to you that a student came into this country on Friday, then are you going to take measures? Is that what you're saying?
Minister.
Yes, and thank you, and measures have already been taken. That student, that Trinidad and Tobago national who came in on Friday, is in self-isolation, and has been since Friday. And that is the protocol being followed around the world. People who are low risk are put into self-isolation instead of institutional isolation. If they present with no symptoms and are deemed to be of low risk, they are put into self-isolation, which has been followed in the United Kingdom, Canada, the United States, and everywhere around the world. And we are no different. We are following international best practice. Thank you very much.
Senator Thompson.
Explain what is meant by self-isolation, because if the student is interacting with the parent who is working outside of the environment, I'm very concerned as to what that self-isolation means.
Minister.
So, self-isolation is a condition imposed for people who pose little or no risk of being able to transmit the disease. You take a note of their travel history, you take a note of symptoms, whether they are febrile or not, you look at their home situation. In this particular case, that student only lives with one person. And so the risk of transmission amongst many family members is close to zero. And self-isolation means they keep a distance from anybody else, normally 3 feet. And close contact means close contact for 15 minutes or more. That is what close contact means in the context of coronavirus. You should not be in close proximity under 3 feet for 15 minutes or more. So those conditions are being applied to this particular student. So that's what self-isolation means. Thank you very much, Madam President.
Questions on notice? Questions for oral answer?
Government business.
Thank you very much, Madam President. Madam President, government is pleased to announce that it will be answering all questions on notice on the order paper.
Senator Mark.
Question number 32 to the Attorney General.
Minister of Agriculture.
Thank you very much, Madam President.
Minister of Finance.
Thank you very much. And just by way of information, Madam Speaker, the government's initiatives to deal with being listed as high-risk destinations or on a grey list are being promoted, and the lead has been taken by the Attorney General. We in the Ministry of Finance provide support because we are quite satisfied that the Attorney General's prosecution of this matter has been very effective and very vigorous, and I want to congratulate him before I go into the answer. The steps being taken by the government to address the EU implementation of the methodology for the identification of high-risk third countries are to address all remaining strategic deficiencies in the national anti-money laundering and combating of financing of terrorism and proliferation financing regime of Trinidad and Tobago, the AML CFT-PF, which are under review by the Financial Action Task Force, FATF. These strategic deficiencies have been addressed by both significant legislative and operational improvements to the AML CFT-PF regime in our country. The government has worked expeditiously to ensure all deficiencies are addressed in order for Trinidad and Tobago to be removed from the public FATF compliance document. More recently, the country underwent an on-site assessment and examination of our authorities by the FATF during the period January to the 6th to 7th, 2020 at the Ministry of the Attorney General and Legal Affairs. The Attorney General and Minister of Legal Affairs will attend before the FATF to receive the outcome of this assessment at the opening FATF plenary meeting during February 16 to 21st, 2020. In other words, Madam Speaker, within the next 2 weeks in Paris, France. In addition, the Attorney General and Madam President, and Minister of Legal Affairs has established regular engagement with the European Commission and its representatives at the FATF and the Caribbean Financial Action Task Force, CFATF, and will continue to do so at the FATF plenary meeting. In tandem with this, and this is where the Ministry of Finance comes in, the government has ensured the deficiencies in the country's tax transparency regime are fully addressed, which is the second component of the methodology to the EU's high-risk third countries. The Joint Select Committee, chaired by myself, has completed comprehensive work on the tax package of legislation, namely the Mutual Administrative Assistance in Tax Matters Bill, the Tax Information Exchange Agreements Bill, and the Income Tax Amendment Bill, in order to ensure full compliance with the requirements of the Global Forum. With the finalization of this package of bills, the JSC received consultation and input from the OECD Global Forum on Transparency and Exchange of Information for Tax Purposes technical team. This has served to ensure that the legislation reflects the Global Forum standards towards achieving a multilateral framework for tax transparency and information sharing. Consequently, the country becoming fully compliant with the Global Forum upon conducting its peer review, which is scheduled for the third quarter of 2020 this year. The tax package bills were carried over on September 20, 2019. The final report of the GSC was laid on November 22, 2019, and will be imminently debated in Parliament. We are also consulting with the EU Ambassador to Trinidad and Tobago and EU representatives based in Brussels for further technical assistance.
Senator Mark.
Madam President, can the Minister indicate, given all the initiatives that have been taken, legislative-wise and from an operational point of view, and the imminent debate that is supposed to take place in our Parliament, can the Minister indicate whether the government is confident that Trinidad and Tobago will ultimately be removed from the EU blacklisting that we have been subjected to for some time? Can the Honourable Minister share that with us?
Minister.
Firstly, Madam President, I don't like that word. The Trinidad and Tobago is on a list of high-risk countries. And yes, barring unforeseen circumstances, we are reasonably confident that we will meet the EU requirements for removal from that list.
Next, Senator Hussain.
Minister, Madam President, through you to the Honourable Minister. Minister, I wonder whether or not the recent events in the European Union regarding Brexit, whether or not this will affect any of the ratings being given to Trinidad and Tobago regarding us being non-compliant.
Senator Hussain, that question does not arise. Next question, Senator Mark.
Question number 33 to the Minister of Works and Transport.
Thank you, Madam President. Madam President, several articles and reports recently published in the media have been based on an article published in April 2019. Coral reef communities in marginal environment along the northeast coast of Trinidad, Southern Caribbean, which was prepared by Belford SG, Philip DAT, Rudford MG, Suchit Roach S, and Duncan EJ. The article highlighted two reef sites along the northeast coastline of Trinidad, Salibe and Grand La'anis Reef. The reef located at Grand La'anis is the smallest of the reefs along the northeast coast. Madam President, NITCO has procured the services of ERM Group to undertake the Environmental Impact Assessment, the EIA, for the Toko port facilities. It is noteworthy that after the article was published, NITCO requested that ERM review the publication. ERM concluded that the data suggests that the Grand La'anis Reef is not as high diverse as the Salibe Reef, and the construction of the port will not lead to a decrease in the species diversity in the northeast Trinidad. In fact, as part of the EIA, ERM is conducting a marine biology baseline study, which includes manual dives and drop camera survey within the project area. This survey has identified 37 benthic invertebrate species, none of which is endangered or vulnerable. It is also noteworthy that the current in the area flows in a westerly direction, and as such, the activities of the port will not have any significant impact on the Salibe Coral Reef or any other reef east of Grand Al-Anis Reef. Madam President, despite establishing that there are no critical, endangered, or vulnerable coral species within the project area, mitigation measures will be implemented to protect the surrounding environment. The following preliminary measures have been identified to protect the reef within close proximity to the project site. Limit the extent of nearshore dredging as much as possible to avoid the removal of coral. Utilize silt fence during dredging and reclamation activities to reduce the dispensation of sediments. Continuous water quality monitoring during the construction and operations of the facilities to ensure that the water quality remain at an acceptable level at all times. Development and implementation of spill management plans, monitoring plans, environmental management plans as a minimum to ensure that the port operates in a manner which does not diminish the water quality below acceptable levels. The data collected from the EIA study is currently ongoing, and further measures will be developed and included in the EIA based on the findings of the EIA study. I thank you, Madam President.
Senator Mark.
Madam President, can I ask the Honorable Minister which agency of the state would have recommended the several mitigating measures that the Honorable Minister outlined in his presentation?
Minister.
Madam President, the process of actually constructing a port like this is well known. You must get approvals from the EMA. You have to submit all the findings. You have to have consultations with all the stakeholders. And until that is completed and the EMA gives you the all clear to go ahead and they give you the required permission and the certification, only then will you be able to start construction. So everything has to be acceptable to the EMA. Thank you.
Senator Hussain.
Thank you very much, Madam President. Can the Minister indicate whether or not a certificate of environmental clearance was granted for this project?
Minister.
Madam President, I think it is clear that I closed up by saying the EIA is an ongoing exercise. And once all the information is gathered, it is submitted to the EMA. Only then will that certificate be granted. Thank you.
Senator Hussain.
President, can the Minister indicate whether or not the EIA will also cover foreseen damages to the reefs that the Minister outlined when the port is operational, or whether or not it's only restricted to the construction of the port?
Minister.
Madam President, in my information, I didn't speak anything about the damage to the reef in the future. This is why you have the EIA. This is why you have that study, and this tells you what to do to protect it while you're in construction and going forward if there's any damage in the foreseeable future. So the EMA takes into consideration the construction and the operations of the port.
Next question, Senator Mark.
Thank you, Madam President. Question number 34 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries.
Thank you very much, Madam President. Madam President, in response to Roman 1, the agreement covers shell production sharing contracts for the East Coast Marine Area, ECME, comprising Blocks 5A, Block 6, Block E, and Block 5C. And in the North Coast Marine Area, NCMA. 1, its Colibri project comprising NCMA 4 and Block 22. The commercial terms of the LNG marketing arrangements for gas for these blocks were improved. The terms of the ECMA PSCs, Block 5A, Block 6, and Block E have been extended to 2030, and that of NCMA 1 to 2035. The quantum of enhanced revenue accruing to government will be dependent on the global market for LNG, and will be realized over a period 2019 to 2027. The pricing regime for LNG will now be based on 1/3 Brent, 1/3 JKM, and 1/3 NBP, as compared to the original contract of a reference Henry Hub price. This new contract is significantly superior to existing regimes, that is Henry Hub, and the Spanish market, and therefore there will be improved returns to the government, but you cannot quantify it until you start marketing the gas. We have a formula. Additionally, Madam President, the Ministry of Energy and Energy Industries received a signature bonus of US $80 million on signing of the new PSCs. With regards to Roman 3, Shell is projected to spend in excess of $1 billion in development works over the period 2019 to 2021. These works are geared to maintain production in its ECMA blocks and NCMA 1 block, and in bringing on stream new production from its Colibri project and Block 5C. First gas from Block 5C is projected for 2021, and for the Colibri project in 2022. Good agreement.
Senator Mark.
President, could the Honourable Minister indicate whether the government undertook an estimated cost of revenue foregone by its decision to extend the license for Shell to 2030 and 2035 respectively, when I understand it was supposed to have been completed and returned to the people of TNT at the end of 2023. Can the Minister indicate what revenue losses we would have foregone?
Minister.
It is obviously that the Honourable Senator doesn't have a full comprehension of what he is saying. We are not foregoing any revenue. We are enhancing our revenue, because the old contract was based on Henry Hub prices, which is the lowest natural gas price in the world because of the surplus of gas in the United States. This new price includes a basket of markets, which is 1/3 Brent, which is reference to crude, which is the highest price crude in the world, to NBP, which is a new balancing point, which is a European market, and most importantly, to JKM, which is the Japan-Korea market. This is enhanced revenue. So I don't know where the Honourable Senator got his impression that is revenue foregone.
Would the Minister be willing to provide his Parliament with details of the terms of the new production contract?
Senator Mark. Minister.
Madam President, as you know, these contracts are covered by non-disclosure agreements. However, I am giving you the basic components of the contract. Okay? And the single most important aspect of gas PSCs is the marketing arrangements. And that is what we have settled over the last 2 years in complex negotiations all over The Hague and in Trinidad and Tobago. And this new pricing formula, let me once again repeat, is significantly superior to the old formula.
Senator Deonarine.
Thank you, Madam President. To the Honourable Minister, through you, Madam President, Could you give us an example of, so for example, the price of natural gas yesterday was around $1.80 US. With this new pricing formula that you have, could you give us a comparison of how much more this new pricing formula would allow us to earn compared to the market price? Thank you.
Minister.
I cannot give an exact calculation, but the gas price you are quoting is a Henry Hub price. Okay? Gas prices all over the world are now depressed. But there was a time when Japan, Korea was paying 3 times the amount that Henry Hub was paying. Now it is about 2.5 times. So I don't want to be quoted as giving a figure, but it will be in orders of magnitude different.
Next question, Senator Obika.
Thank you, Madam President. Question number 65 to the Minister of Energy and Energy Industries.
Minister of Energy and Energy Industries. Minister of Finance.
Thank you, Madam President. I assume everybody's hearing me. Petrotrin has 2 pension plans, namely the Petrotrin Employees Pension Plan and the Staff Pension Plan. The last actuarial reports were prepared for the 3 years ending in September 2016 and are thus out of date. In or around November 2019, a report was produced for simulation purposes, which sought to address the long-term impact of Petrotrin's restructuring on the 2 plans. Based on the simulation report, the staff pension plan has adequate resources to meet all of its obligations, whereas the employees' pension plan shows a possible deficit in 25 years for the scenarios that were simulated. Petrotrin has advised that actuarial valuations for the 3 years ending in September 2019 are currently in progress and would provide more accurate information on the actual funding status of both plans. These reports should be completed by June 2020. In addition, the Ministry of Finance has commissioned an independent actuary to conduct an independent valuation of the plans and their ability to meet their liabilities, to provide the best possible information for decision-making purposes. This independent valuation should also be completed by June 2020.
Senator Obika.
Can the Honourable Minister indicate how many employees, how many persons on the employees' pension plan stand to be affected by this named deficit in the plan as it proceeds?
Minister.
Absolutely none, because the government will take whatever action is necessary.
Senator Obika.
Can the Honourable Minister indicate when would the government be required and the taxpayer be required to support the deficit in this employees' pension plan for the after the closure of Petrotrin?
Minister.
Thank you, Madam President. I have not yet attained the status of a psychic or a seer man. I would have to wait until the actual report is delivered in June 2020 before I could answer that question.
Senator Obika.
President, can the Honourable Minister indicate, therefore, if the fund is generally underfunded or if only one of the pension funds is underfunded?
Senator Obika, I won't allow that question. Any further questions? Senator Mark.
I ask the Honourable Minister whether there is any deficit or if there is a deficit in the current Petrotrin pension fund, particularly as it relates to the Petrotrin workers, not the Tesoro workers, the Petrotrin workers, Madam President.
Senator Mark, I won't allow that question based on the answer that was given. Next question, Senator Obika.
Thank you, Madam President. Question number 66 to the Minister of Labour and Small Enterprise Development.
Minister of Labour and Small Enterprise Development.
Thank you, Madam President. Madam President, the decision announced by the Minister of Finance in the 2020 national budget points to the strategic direction that the government of Trinidad and Tobago intends to follow regarding the enhanced regulation, supervision, and development of cooperative societies. Questions relating to the human resource arrangements for cooperative development officers currently working in the Cooperative Development Division of the Ministry of Labor and Small Enterprise Development are operational issues which can only be addressed as part of an overall action plan involving an in-depth discussion and consultation with all stakeholders, including the representing trade unions. The focus of the ministry is to support the institutional strengthening of the Cooperative Development Division. As a result, in keeping with the decision of Cabinet, discussions have been initiated with the Governor of the Central Bank of Trinidad and Tobago to provide technical support in areas such as 1, on-site inspection and examinations of credit unions, 2, assessment and analysis of financial investments, 3, risk-based supervision of credit unions, and 4, reconstruction and liquidation. In addition, Madam President, to ensure that the cooperative development officers are in possession of the requisite skills, the Central Bank has agreed to ensure that the necessary technical training as it relates to the financial and supervisory function are made available to the current staff of the CDD. This is one aspect of an overall program to ensure that the staff of the Cooperative Development Division are equipped with the necessary competencies to perform their jobs, and that the CDD is fully staffed with the human resources necessary for the development of the cooperative sector in Trinidad and Tobago. Finally, Madam President, the government of Trinidad and Tobago is also focused on the strengthening of the Cooperative Development Division through the filling of all existing vacancies by the Director of Personnel Administration in order to boost the administrative and regulatory functions of the division. Thank you, Madam President.
Senator Obika.
Madam President, can the Honourable Minister, notwithstanding the collaboration between the CBTT and the Cooperative Division, can the Honourable Minister indicate whether there's a timeline for the operationalization of this authority for cooperatives?
Minister.
Madam President, as one would appreciate, the establishment of such an authority will take some time, hence the Cabinet's decision for me to proceed as the line minister to engage in the institutional strengthening of the division by equipping the officers with new skills and competencies to monitor and to advise the credit union sector in terms of the multi-million-dollar investments that are being made.
Senator Obika.
Given the difficulty with establishing a timeline for public knowledge, can the Honourable Minister indicate whether or not the fears of the staff at the division regarding possible redundancy are well placed, or if they will have no problems with their jobs, provided this timeline gets in effect?
Senator Obika, I won't allow that question. Any further questions? Senator Obika.
Probably try to rephrase in a better way. Can the Honourable Minister indicate whether or not the authority's creation will result in job redundancies at the Cooperative Development Division?
Minister.
President, I am happy to respond to that question because we would have addressed, when I say we, the permanent secretary at the ministry and other members of the executive management team would have met with the staff and addressed all their concerns. There is absolutely no expectation of any redundancy, and I hope that such language would be put to rest this afternoon.
Senator Obika.
Thank you, Madam President. And the final question I have on this matter is will the authority result in dual regulation of the cooperative sector, in particular credit unions,
Senator Obika, I won't allow that question. Next question, Senator Obika.
Thank you, Madam President. Question number 81 to the Minister of Works and Transport.
Minister of Works and Transport.
Thank you, Madam President. Madam President, the answer to part one, the contract document provides for a defect liability period of 18 months. Additionally, the contract makes other provisions to safeguard the integrity of the project in the form of performance bonds and retention. Part two, in accordance with the contract, remedial work for the road paving work in question have begun and are ongoing. The Ministry of Works and Transport will, in this case and in all such cases, seek to ensure that the required quality and standards are achieved. I thank you.
Senator Obika.
President, can the Honourable Minister indicate the number of contractors that were involved in the project cited?
No, that question does not arise. Senator Hussain.
Madam President, could the Minister indicate whether or not, if this was one of the road paving exercise leading up to the local government election last year that the government hurriedly done in order to win this
let me stop you.
election?
Let me stop you. That question does not arise. Catch your breath and now ask the question.
Sir, can the Minister answer whether or not,
yes,
sorry, who is the contractor for this particular project?
Minister.
President, like this project and all other projects undertaken by this government, this was a process, a tendering process conducted by NIPDEC. On this project, I think we engaged close to 8 contractors, 2 of which were paving contractors. The rest would have been smaller contractors, all on the tendering basis. The piece in question is a paving job done by one of the more reputable contractors in Trinidad. Unfortunately, there was a challenge with the mix, and the contractor agreed under the terms and conditions of his contract to have it redone. I don't know if you want me to go in further than that. If you want, it's unfortunate if I have to come to the Parliament and call contractors in names. So I really would try to avoid that, but if the President insists.
Senator Hussain.
Sir, can the Minister answer whether or not the remedial works will be any additional cost incurred to the state, please?
Minister.
President, I think it was clear there's a defect liability period, which indicates that the contractor will repair the job at his cost. Once we find a defect on a job that has an 18-month defect liability period, and you identify anything within that 18 months, then the contractor does it at his cost. And I can tell you, since 2015 to now, this government have utilized that clause. Thank you.
Senator Hussain.
Can the Minister indicate how long it will take for these remedial works to be conducted, please?
Minister.
Madam President, this job would have started a couple days ago. The area have already been stripped. They have put in this stabilization. It has to take about 2 or 3 days before they do the final paving. We are hoping to have this job completed by now on weekend. By now on this weekend.
Public business, government business, bills, second reading.
Minister of Finance.
Thank you, Madam President. I assume everyone is hearing me. Just checking the sound system. Madam President, the Insurance Act 20, oh sorry, my apologies. I beg to move that a bill entitled An Act to Amend the Insurance Act 2018 be now read a second time. The Insurance Act 2018 was passed in the House of Representatives and in the Senate in February of 2018 and May 2018 respectively, and was assented to by the President in June of 2018. It will come into force upon proclamation by Her Excellency the President. Various versions of this act were laid in the Parliament between 2011 and 2016, before finally being passed and enacted in 2018. It is the product of 4 joint select committees of Parliament and an exhaustive consultation process with industry stakeholders and the public. In the 2010 to 2015 period, there were 3 failed attempts to get this insurance bill addressed and dealt with by the Parliament. It was eventually sorted out when this administration came into office, and I had the privilege to chair a joint select committee dealing with the insurance bill. The Insurance Act is an extremely complex piece of legislation. It contains 282 sections, 12 schedules, and 10 regulations which will be laid in due course to support it. During the debates on the 2018 Act, we recognized that amendments to the Act would be required as it becomes operational. And this is in particular to comments made by members of this Honorable House, senators. Arising from those comments made in the Senate in particular, the Central Bank conducted a review of the 2018 Insurance Act and consulted with industry stakeholders on the new regulations to support the Act. Based on this review and consultation, the Central Bank has recommended a number of amendments for a smooth implementation process with which the Cabinet has agreed to support. The Insurance Act 2018 is necessary to bring the industry into the 21st century, and by extension, this Insurance Amendment Bill 2019 hones the provisions of the regulatory framework to which this Parliament has already agreed for a safe, modern, stable, and growing financial sector. And in passing, Madam Speaker, the Central Bank and the Ministry of Finance have had a visit from a joint team from the World Bank and the IMF who came at the request in particular of the Central Bank at a visit to Washington last year. And this particular joint World Bank IMF team was asked to conduct a review of our financial services sector, of which the insurance industry is a significant part. So if anybody wants to know why the IMF is here, they're not here for an Article 4 consultation. They're just here as part of a project which was requested by the Ministry of Finance and the Central Bank in particular to look at our insurance industry, look at banks, look at unit trusts, look at credit unions, look at the whole range of financial services that are offered in Trinidad and Tobago, and to identify strengths and weaknesses so that we in government and the regulators can take whatever action is necessary. I can't emphasize how important it is, not just to the insurance industry and the public, but also to the wider economy, to have relevant legislation and regulations to govern the conduct and trade of the insurance industry, which currently comprises 12 life insurers, or life insurance companies, 19 general insurance companies, and close to 3,000 brokers, adjusters, agents, and salesmen. The insurance and pension industries are long-term investors in projects, businesses, and the country's infrastructure, and thereby facilitate sustainable growth and economic development. The assets of the insurance industry total 48 billion as at September 2019 and account for approximately 29% of the GDP of Trinidad and Tobago. Assets under management for the pension sector totaled 51.1 billion in September 2019 and accounted for 31% of our GDP. The combined assets of the insurance and pension sector is thus of the order of $99 billion, or if you do the math, almost 50% of our GDP, of which more than 1/3 is invested in securities issued by the government of Trinidad and Tobago. The implementation of the Act, the Insurance Act that is crucial for the resilience of the financial sector. This will be reflected in the said report I just referred to, the World Bank IMF Joint Financial Sector Assessment Program, also known as FSAP for short, on Trinidad and Tobago. In the past, legislative gaps in the Insurance Act, the old Insurance Act, have been repeatedly identified as needing legislative attention. Now that the Insurance Act 2018 exists, it is anticipated that this country will be assessed under the FSAP based on the proclamation and effective implementation of this new regulatory regime for insurance. The Insurance Amendment Bill, I'm advised, is a vital prelude to the proclamation and smooth and proper operation of the 2018 Act. The bill before the House effectively seeks to tidy up, or before the Senate, seeks to tidy up certain provisions of the 2018 Act and lend greater harmonization in the regulation of the sector. There are a number of mixed group structures in Trinidad and Tobago whereby regulated entities and unregulated entities coexist in one group. These structures make it difficult to assess the risks to which regulated industries are exposed. And I can think of many conglomerates, Massey, ANSA, the failed CL Financial conglomerate, and so on, where you have a multitude of entities, some of them regulated, some of them not regulated. The Insurance Act 2018, the new act, gives the regulator the power to require restructuring of business groups that engage in financial and non-financial activities to form a financial holding company to hold exclusively the regulated financial entities in the group, for example, banking and insurance. At this time, there are 5 major mixed groups in Trinidad and Tobago, where each single group consists of both insurance and banking. The combined assets of the regulated industries within these 5 mixed groups are approximately 1/3 of the total assets of the financial sector, so it's significant. And if you again do the maths, that would be over 15% of our GDP, closer to 17%. Harmonization of the Financial Institutions Act and the 2018 Insurance Act is also critical for the supervision and oversight of financial groups, which include non-bank institutions. For this reason, the Insurance Amendment Bill before the Senate proposes minor amendments to harmonize the 2018 Act and the Financial Institutions Act. For example, the definition of control, controlling, and significant shareholders, the restructuring of related group companies, treatment of credit exposure, compliance directions, regulation-making power, and the participation of insurers in an alternative dispute resolution scheme to benefit policyholders. Many provisions within this bill are also intended to correct what I will call typographical errors, errors in cross-referencing, grammar, and syntax. I therefore do not propose to traverse the bill clause by clause, but just deal with the important areas. Central to the proper administration of the Insurance Act 2018 is a clear definition of control and carrying on insurance business. Clause 6 and 11A of this bill before the Senate seek to provide further clarification on these definitions, which are set out in Section 6 and 21 of the 2018 Insurance Act. Another important aspect of the Act is its application to regulated entities. Clause 11B of the bill seeks to amend Section 22 to make it clear that intermediaries, when conducting the business for which they are registered, will not be caught within the meaning of the term carrying on insurance business, and so require registration as an insurer. This implements a recommendation for an industry so that persons who provide services to insurance companies that are not insurance services would not be caught within the meaning of carrying on insurance business. A crucial power in the regulatory toolkit is the power to request information from persons exercising varying degrees of control, which is what Parliament agreed to in the 2018 Insurance Act. Clause 8 clarifies that the Inspector of Financial Institutions can also request information from acquirers, persons who are acquiring insurance companies, under Section 11 of the Act. For the first time, the new Insurance Act will seek to restrict the use of words or any of their derivatives, or any other expression that connotes or intended to connote insurance business. Clause 12 seeks to amend Section 21 of the Act for clarity, consistency, and the flexibility of the High Court to make appropriate orders in relation to breaches thereof. Section 4.2 of the Financial Institutions Act introduces a similar restriction on the use of the word bank or any variation of the word form that forms a part of the word bank. And Madam President, just to digress, in the other place I had just used by way of example, that where we want to now make sure that no person who is not a registered insurance company can call themselves an insurance company or can make as if they are carrying on insurance business. By way of example, I referred to lawyers, doctors, and so on. And for some reason, rather than focusing on the subject matter, which is the fact that we are simply trying to ensure that persons cannot portray themselves as insurance companies, the reporter chose to quacks and I'm not able, no? So let me just reinforce that what we are doing here is making sure that persons cannot represent themselves to be insurance companies or insurance entities or carrying on the business of insurance or in some way engage in the business of insurance. In the same way, this is restricted with respect to bank, and it's also restricted with respect to a number of professions. I would not give the person the opportunity to reiterate what I said in the other place. You would appreciate that a smooth transitional process is essential to maintaining the stability of the financial system, which benefits the industry and Trinidad and Tobago as a whole. For that reason, Clause 13 of the bill seeks to amend Section 22 of the Act to clarify inter alia the stated capital requirements for the composite insurance companies registered under the 1980 Act that are to be grandfathered under Section 23 of the 2018 Act, so that there would be some companies who may not meet precisely the new capital requirements and they will be grandfathered, but there will be specificity with respect to the capital requirements of composite companies registered under the 1980 Act. Further, Clause 14 of the bill amends Section 23 of the Act to clarify the process for an insurer registered under the Insurance Act 1980 to obtain a new certificate of registration, especially where its old certificate of registration has been lost or destroyed. Under the 2018 Act, only companies incorporated under the laws of Trinidad and Tobago can apply for registration as an insurer. I just want to make this point clear. We are doing away with foreign insurance companies. That will be a thing of the past. So in order to carry on insurance business in Trinidad and Tobago, once this act is proclaimed, which we expect to be proclaimed within the next 2 months, if not before, then in persons carrying on insurance business will need to incorporate themselves and register as a Trinidad and Tobago company. Therefore, Clause 15 of the bill amends Section 24 of the Act and deletes the reference to foreign company, which is no longer relevant because foreign companies in the insurance business will no longer be allowed to exist. So that's a tidying up amendment. Clause 17 of the bill amends Section 29 to match its intention that all insurers would have to meet registration requirements detailed in the Act on a continuous basis. This clause now makes this crystal clear. Madam President, it is also paramount that registered insurers do not conduct regulated business with unregistered persons or companies. Clause 18 of the bill seeks to clarify this prohibition in Section 31 of the Act, as well as introduce another exception to restriction on business activities registered insurers may conduct. This is necessary to allow for the Export-Import Bank of Trinidad and Tobago Exim Bank, which is a government special purpose company, to continue to carry out its public functions. Exim Bank is a registered insurer under the 1980 Act, is something I only recently realized. And pursuant to its mandate, conducts business activities outside of those specified in the 2018 Act. It has a very limited insurance portfolio. Started off as an insurance company, but now, of course, it deals with facilitating exports in particular. The amendments to subsection 5, 6, and 8, and the introduction of a new subsection 13 in section 30 will allow Exim Bank to continue to fill its public function without contravening the 2018 Act, and its public function is to facilitate exports. Clause 20 of the bill seeks to amend Section 43(2) of the Act, Insurance Act that is. For clarity, inserts a new subsection 3, which provides the inspector with the necessary oversight powers to ensure fair and equitable treatment of participating policyholders. This is something that arose from consultation with the industry. Clause 21 of the bill amends Section 44 of the Act to provide further clarity, especially for instances where an insurer may make a withdrawal from its catastrophe reserve fund. This is especially important as the 2018 Act now makes it mandatory for all insurers conducting property insurance business to establish and maintain a catastrophe reserve fund. Clause 21 also clarifies that an insurer may make withdrawals from the catastrophe fund when it exceeds 120% of its net written premium in relation to its property insurance business, provided that in so doing, it would not breach any of the stated requirements. Again, this is for clarity. Clauses 22, 31, 72, and 73, which introduce a new section 48A and amend section 64, 263, and 265 of the Act, serve to clarify when a vesting order would be applicable. A vesting order allows the transfer of assets from one company to another in a single legal instrument. The availability of this mechanism is particularly important for branches of foreign insurers, which now exist, who will be required to transition to companies incorporated in Trinidad and Tobago, and for groups which are subject to mandatory restructuring under sections 47 and 48 of the Act. And let me clarify this further. When the Insurance Act is proclaimed, which, as I said, should be within the next 2 months, foreign entities who now operate by way of having a branch in Trinidad and Tobago will have to transition to a local company and establish a company incorporated in Trinidad and Tobago. So they will be forced to do so by law. And groups will also be forced to restructure in accordance with section 47 and 48 of the Act. So they will have to create companies, local company in one place, holding company, financial holding company in another instance. We are forcing them to do that. And they will have to transfer whatever assets are associated with that particular business, insurance as the case may be, financial services as the case may be, to these new entities. So we are forcing them to do that. Normally there is a charge of stamp duty when you transfer assets, but since this is something that is being imposed by the government, this vesting order and the arrangements surrounding the vesting order will allow the exemption from stamp duty. Clauses 25, 26, and 27 amend sections 52 to 54 of the Act to provide further clarity on the procedural requirements that apply to controlling shareholders, significant shareholders, and acquirers of insurers in a simplified fashion. In order to integrate the procedural requirements of the Insurance Act with the Companies Act, Clause 30 amends Section 63 of the Insurance Act to require insurers to file schemes of transfer approved by the central bank with the Registrar of Companies. Madam President, good corporate governance practices create an atmosphere of transparency and accountability. These principles are very present in the Insurance Act 2018. However, the central bank told us that there were a few places where an opportunity to apply corporate governance could be improved. Some amendments, like those to clauses 13, 17, 35, and 52, amending sections 22, 29, 69, and 116, rectify those omissions and clearly define the role of the board and senior management in transition plans and declarations which must be submitted to the central bank. Clause 38 of the bill amends section 82 of the Act to minimize risk as far as possible during the transitional capital ratio period of 5 years. This is another mechanism for clarifying capital requirements during the transitional period post-proclamation. Further, a central premise of the 2018 Act is the concept of risk management and risk mitigation. One way to achieve this is by imposition of concentration limits on credit exposures incurred by insurers. Section 89 of the Act provides that an insurer shall not incur credit exposures to a person in excess of 25% of its capital base. However, Section 89(1)(a) provides for an exception to this prohibition in relation to a credit exposure that is fully guaranteed by the government of Trinidad and Tobago. And we also did this the other day with respect to banks, so that it allows governments to be involved in credit exposure facilitating financing by the commercial banking sector of the government's development program and so on. And this will now assist insurance companies to also get involved in financing the government's development program. The provision as currently worded did not provide conditions the guarantee had to meet in order for it to qualify for the exception, as it already does under the Financial Institutions Act. Accordingly, Clause 41 of the bill amends Section 89(1)(a) to introduce criteria that the credit exposure to the government must meet in order for it to be exempt from limits. Clause 42 of the bill also amends Section 94, subsection 4, for clarity on the exposure limits in relation to directors and officers of insurers and their relatives. An error in respect of the application of temporary cover to life insurers to reflect the current status quo in the industry is corrected in Clause 43, which amends Section 92, subsection 1(c)(i). Clauses 46 and 47 of the bill amend Sections 101 and 107 of the Act to clarify the priority and source of funds for the payment of the cost of suspension and winding up. And Madam President, the 2018 Insurance Act introduces for the first time the concept of provisional certificates of registration for sales representatives that do not have the educational qualifications necessary to be considered fit and proper for registration, but have been endorsed by their principal. The Act currently makes provision for insurers and brokerages to endorse their sales representatives, which would allow them to work in a limited capacity under the direction and control of a registered intermediary. Clause 51 of the bill introduces an amendment to provide for the equal treatment of sales representatives of insurers, agencies, and brokerages by allowing sales representatives of agencies to apply for provisional certificates of registration. So what we are doing here is allowing persons who may not meet all of the qualifications required to be insurance salesmen or salespersons or saleswomen, but they will be working under supervision and they will have provisional certificates of registration. Clause 55 of the bill inserts a new subsection 5 in Section 136, which specifies that the financial statements of agencies and brokerages are to be audited by an auditor that is fit and proper and a practicing member in good standing with ICAT or such other professional association approved by the central bank. And this is very important. We have had instances of persons, auditors who are on suspension, who are under investigation, or who have been struck off the list, that attempt to audit the accounts of companies. And so this now makes it crystal clear that such an auditor must be fit and proper and a practicing member of ICAT or any other approved association. Clause 57 of the bill amends Section 155, mainly for clarity. However, it merits mention that the language in Section 155, subsection 1c, is very broad. It was felt that the inspector should not issue compliance directions for the violation of any provisions of any law, as it is now worded, but only those related to the regulation of financial services or designed to protect against fraud. This is a more objective criterion for the exercise of the inspector's powers. So we are reducing the powers of the inspector and putting them in context, so the inspector can only issue compliance directions when it relates to a violation of regulations dealing with financial services or there's some element of suspected fraud. Clauses 68 and 71 amend sections 251(1) and 255 of the Act to rectify the ambit of prosecutorial proceedings brought under the Act, to include all relevant regulated persons to which this section applies. Clause 76, which amends section 281, refines and makes clearer how branches of foreign insurers are expected to reorganize their businesses to come into compliance once the Act is proclaimed. And again, I want to repeat, after the Act is proclaimed, no longer would there be any foreign insurance companies in Trinidad and Tobago. At the beginning of this presentation, Madam President, I spoke of the need for harmonization between the FIA and the Insurance Act. This is necessary to ensure that the central bank regulates the various members of financial groups, which may be a combination of insurance companies, banks, and non-bank financial institutions in a like manner. An example of this is at Clause 67, which seeks to introduce a new Clause 250A that provides for insurers to enroll in an alternative dispute resolution scheme approved by the central bank. Insurers already participate voluntarily in the ADR scheme administered by the Office of the Financial Services Ombudsman, so this should not be too onerous. It is also a requirement for licensees under the Financial Institutions Act, who also participate in this ADR scheme. This is necessary for consumer protection. Another aspect of the regulatory scheme introduced under the 2018 Insurance Act is the ring-fencing of financial entities in a group. In order to ring-fence the financial entities, mixed groups will have to restructure, placing the financial entities under a financial holding company, and the resulting structure will allow for consolidated supervision. The 2017 JSC, which I had the privilege to chair, was of the view that restructuring under Section 47 of the Act should not be subject to stamp duty. This is something I referred to previously. Considering that restructuring under Section 48 and 281 would also be mandatory, the automatic exemption from stamp duty should extend to all forms of mandatory restructuring. In other words, we are forcing them to restructure. We are forcing them to incorporate local companies, and therefore they should be exempt from stamp duty when they take the assets from the existing conglomerates and put them into these financial holding companies or these local companies. Clause 73 of the bill amends Section 265 of the Act to make provision for stamp duty exemption for all forms of mandatory restructuring under the Act. The power to make regulations is also an important step in the process of operationalization of the legislation. The Insurance Act 2018, as currently worded, contains a brief and rather wide-ranging power to make regulations. It was felt that the language of the 1980 Act provided greater guidance on the use of regulation-making powers. Accordingly, Clause 75 of the bill amends Section 279 of the Act to introduce a non-exhaustive list of matters for which the minister may make regulations to support the legislation. In other words, tighten up the areas where the minister may make regulations. Don't leave it open. These provisions were crafted by combining the 1980 Act and similar provisions in the Financial Institutions Act and adapting them to make them consistent with the 2018 Act. Sections 184 and 185, as well as Schedule 12 of the Act proposed to amend the Married Persons Act. The government was of the view that those provisions should not be proclaimed until Parliament has had an opportunity to interrogate more comprehensively the effect of the proposed changes to the law as it relates to married persons and insurance. Clause 77 and 82A of the bill address this decision. Finally, Madam President, Clause 82B introduces a few consequential amendments to Section 56, subsection 1 of the Central Bank Act for the avoidance of doubt on the protected status of information received from trustees and beneficiaries of private pension fund plans. Just like the Insurance Act 2018, the amendments in the Insurance Amendment Bill, the bill before the Senate, reflect the implementation of the insurance core principles of the International Association of Insurance Supervisors, and those are the guiding principles. This framework is critical for creating and maintaining a stable and growing insurance sector in Trinidad and Tobago that engages in safe and sound practices, is fair to policyholders, and can successfully weather a financial crisis with minimum disruption. Before I close, Madam President, we did have some comments on the Insurance Amendment Bill from the ATIC, the Association of Trinidad and Tobago Insurance Companies. We sent those comments to the Central Bank. We also sent them to a learned senior counsel. And at this time, we don't see any need to make any further amendments at this time because we think all matters have been adequately addressed. I want to stress before I close that this amendment bill is the product of a request that came from the regulator. This is not the government invention. This is not some sinister plot on the part of the government to amend the 2018 Insurance Act to benefit certain unknown persons, as was falsely stated in the other place. These amendments have all come from the Central Bank, which is the entity that has to regulate the insurance industry. They asked us, the government, to hold our hand with respect to the proclamation of this act while they, the regulator, could consult with industry, review the act, look at best practice, look at what is happening in the world, and ask us to make amendments. We have looked at what the Central Bank has asked us to do, which is the bill before you, and we are in agreement. I beg to move, Madam President.
Honourable Senators, I shall now propose the question for debate. The question is that a bill entitled An Act to Amend the Insurance Act 2018 be now read a second time. Senator Mark.
Thank you, Madam President. I would have liked the Central Bank to have come before a joint select committee of this honorable Parliament so we could have interrogated the Central Bank on some of these proposed amendments. But the Central Bank is not here. Who is here? The Minister of Finance. He will have to take the licks for the Central Bank, who is not here. Madam President, I think it was Mighty Sparrow in the early 80s who sang a classic, Capitalism Gone Mad. And Madam President, when we examine this document, and we relate it to not only one document, Madam President, this big fat Insurance Act of 2018, this is related to the Central Bank Act. This is related to the Insurance Act of 1980, 38 years or 39 years old. So we are not just dealing with these amendments that the minister, I guess confession is good for the soul. So he confessed to us this evening, like Shaggy, don't blame me, blame the central bank. It's they who asked for it. But who bringing it here? Who bringing it here? It's the Minister of Finance, and by extension, the government. Madam President, I want to say this afternoon that the measure that is before us, simple as they may appear, technical as they may seem, at times confusing to many of us. And Madam President, it is the last time we on this side will be facilitating this kind of arrangement where we don't get sufficient time to study legislation. They are rushed. The governor, the central bank, the finance minister, the government had months to study this piece of legislation. We are given a few hours to do it. We are taking it for the last time. So we serve notice on the government. Don't come back with this kind of rush legislation to this parliament. Madam President, I listened very attentively to the Honorable Minister. Not once in his presentation did the Honorable Minister make reference to CLICO. Not once did he make reference to the disposal of the CLICO insurance traditional policy holders portfolio to a company called Sachiko. Not once. But Madam President, when you look at this piece of legislation, the heart and soul of this legislation is to continue the facilitation of the sale of CLICO portfolio assets and insurance, whether it's life, whether it's general, whether, Madam President, it is pension related, all of that is going to who? And Madam President, you know what is ironic about the presentation that I heard? We are getting rid of foreigners. No foreigners will be able to come and run operations in Trinidad and Tobago unless they're incorporated. That is now a law, and we are changing that. What's new? What's new? Madam President, what the Honorable Minister didn't tell us is that there is a foreign company called Alinvest out of Ontario, Canada, that purchased Sagicor, which is no more. There's a new Sagicor, and the new Sagicor is owned by a foreign company called Alinvest. And Madam President, under the laws of Canada and Ontario, there's something called a specific, it's called SPAC, a specific purpose acquisition company. This company called Alinvest came on the scene in 2017. 2017. We are now in 2020. And Madam President, they found themselves in a place called Ontario. And you know what they did, Madam President? They raised between $500 million US and $2.6 million US in Canada. And guess what? They bought out Sagicor of Barbados for $536 million US. So Sagicor, like CLICO, is no more in Barbados. We have lost Sagicor, and what we have is a front called New Sagicor. And who is the real owner? Alinvest. Who are they? Canadians, many of them. I have nothing against Canada, Madam President. I love Canada. I go to it. I go to Canada. But I am saying when we are dealing with matters of the public interest, Madam President, the Minister of Finance has a duty to come clean and tell this country what this thing is about. Madam President, I have evidence here, but I wouldn't expose all today. But Madam President, when you hear about the players involved, it is Republic Bank is part of it, Madam President, if you hear the big players involved in this move to take control of this economy, it will send chills up your spinal column. But we are being told here today, these are simple amendments. And the minister goes through it like if it's nothing. When the minister ought to know, and Madam President, if he doesn't know, let him be informed that what this parliament is being asked to do today is to deal with amendments that will consummate. And I'll tell you how it will be consummated. Madam President, a sales and purchase agreement has already been signed between the central bank and Sagicor Alliance, and it will take them months, if not a year or two, to make the schemes of transfer real. And by that time, we are told by the distinguished, illustrious, and honorable minister, in February, March, these laws will be proclaimed. Both the Insurance Act of 2018 and, Madam President, what we are debating today. And what we are debating today will now lay the framework and the passageway for a foreign company called Alliance to take control of our local CLICO policy holder portfolio. Madam President, you know how much is it valued? It is valued at $8 billion, 1.2 billion US dollars. And that is going where? In the hands of a foreign company called Alliance. And they kept the brand, Madam President, they kept the brand Sagicor. So Sagicor is there. And we telling ourselves, and people might tell themselves, Madam President, that is Sagicor of 175 years old out of Barbados. That is not the Sagicor out of Barbados, 175 years old. That is new Sagicor that was bought out for $536 million US dollars by a company called Alliance out of Canada. That was formed, Madam President, fly by night, 2017. And Madam President, in 2.5 years, we are now debating, transferring through all these amendments here, Madam President, deletion, repeal, amend. All of these amendments, Madam President, are designed to achieve that objective at the end of the day. I think the time has come for us to have a forensic criminal inquiry into this matter. Madam President, I don't have the resources, but I believe that when you connect the dots, a fellow called Michael Leachin out of Jamaica, who is a big billionaire with Canadian citizenship, when you connect the dots, I believe that this man is behind Alliance.
Mark, if I may, you have now been speaking for over 10 minutes, and you have spoken on this matter for the full 10 minutes. I will ask you now to move on to other aspects of your presentation.
President, and I shall connect the dots as I proceed. I'm sure you'll allow me to do it. This is a serious matter, you know, Madam President. Madam President, may I tell you something? We spent nights here in these hollow chambers and walls. 4 joint select committees looked at this insurance fat bill of 333 pages. And Madam President, we debated it. We passed it. Madam President, you know when we passed it in our house? I think it was April or May. You know when it was assented to? In June of 2018, and the minister confirmed that a short while ago. Madam President, 12 months in the year 2019, 6 months in 2018, 12 and 6 is 18, January is 1, 19, 19 months. Madam President, go to clause 279 or section 279, 1 and 2 of this Insurance Act. You will see where regulations to govern this act were supposed to be tabled and debated in this Parliament. Negative, you table, we bring a motion. Affirmative, you must debate. Madam President, we are now debating a second set of amendments to the same Parent Act. And Madam President, you know what? The regulations have not been laid. After 20 months, the regulations governing the Insurance Act of 2018, Act number 4 of 2018, has not been laid. And what the minister tells us now, in 2 months' time, the law will be proclaimed. Madam President, if you proclaim a law and there are no regulations to govern the laws and the provisions contained therein, what effect that will have, Madam President? So, Madam President, I am very, very concerned with what we are being asked to deal with here today. I believe that we in this Parliament are being taken by external forces for a ride. And we are being used, Madam President, as a rubber stamp Senate to accomplish other persons' ambitions and desires. But as so long as I can breathe and I can research, I will expose the shenanigans of those who have their own objectives and own goals. So, Madam President, I will take your very wise counsel and let me try to deal with some of the measures that is before us. Madam President, if you even go to the definition section, which is section 4 of the legislation, you will see how the government is seeking to water down the legislation. And you ask yourself, why is the government seeking to water down the legislation? Madam President, who can object? Having gone through the CLICO experience of 2009, not supporting strong regulation so we can build a solid financial services sector, because we understand the importance of that sector to our economy, the kind of foreign exchange it can generate. So we need to have a strong, regulated financial sector. And we were told by the Minister of Finance that sector is valued at almost $100 billion. Pensions is 99 billion or some 51 billion. The rest in assets of insurance is another amount, Madam President. But it is billions, tens of billions of dollars. So, Madam President, I went through sections of these definitions, And I'm seeing, Madam President, where efforts are being made to tighten the various definitions. I see also, Madam President, where they are seeking to delete the word property, where it appears, and replace it with the word assets. I saw that in the definition section. I saw where they replace foreign company with the word foreign insurance company. Again, Madam President, why foreign insurance company? You move from foreign company to foreign insurance company. That is to facilitate the company called Sagicor, which is foreign to us, and that is to facilitate the owners of Sagicor, Alinvest, which is foreign to us. So again, Madam President, you can see the dots being connected in this matter that is before this Honorable Senate. Madam President, there is something that I saw that had me a bit concerned, and I wish to draw it to your attention. Madam President, it deals with Section 7, or you could say Clause 7 of the Act, Madam President. And when we go to D of that particular section or clause, it says Section 10 of the Act is amended, Madam President. And when you go to D, it says that, it says subsection 14, delete the word audit or cause to be audited and substitute the words examine or cause to be examined. And Madam President, you ask yourself the question, why would the minister want to do that? I noticed in his contribution he did not deal with that matter at all. But to understand Section 10 or Clause 7 of Section 10, Madam President, you will permit me to go to the Parent Act, because it is the Parent Act that we are amending. So we have to refer to this particular section of the legislation. So in this section, Madam President, we go to what is called subsection 14 of this particular section. And Madam President, if you will follow it, I don't know if you have a copy, it's a very voluminous document. And under 14, if I may quote for you, what is here is we have somebody called Inspector of Financial Institutions. And by the way, Madam President, I want to ask the Minister of Finance, why is the Inspector of Financial Institutions one Mr. Patrick Solomon, no relationship to the dead Patrick Solomon? He is the the Inspector of Financial Institutions, Madam President, and he has been acting as if he's a star in Hollywood for the last few years. And this matter that we are investing more power in this particular office holder, we want to know why the government has this individual who is the Inspector of Financial Institution acting and not taking steps to appoint him permanently to the post. So I raise that a passant, Madam President. Madam President, I want to also ask you to pay attention to this section. It states, Madam President, the inspector may audit, this is in the original act, Madam President, audit or cause to be audited the records of approved educational institutions and intermediaries in order to verify that the information contained in what is called the CPD. Madam President, CPD means continuing professional development. That is what it means. And this inspector has to validate by verifying whether this individual would, in his CPD returns, whether he would have done what he claimed to have done. Madam President, with the greatest respect, I thought we had in this country something called the Trinidad and Tobago Accreditation Council. And I thought that they were responsible for educational institutions. But here it is, we are giving the inspector, Madam President, the power to audit or to cause to be audited the records of approved institutions, educational institutions. So again, I draw it to your attention.
Senator Mark,
Yes, ma'am.
unless I am mistaken, you are speaking to the Parent Act. What is in the Parent Act? That's what you're taking issue with.
No, what I'm saying is that there's an amendment to
Right,
this section.
but when you were just speaking, you were speaking to the Parent Act and not to the amendment, which is what I'm trying to draw to your attention. No, continue.
You'll agree with me that there is an amendment to the Parent Act, and they are removing, Madam President. Madam President, I don't know if you studied as I did, but I did a lot of study. I don't joke when I deal with these things, even though I have limited time.
Well, I hope
So,
you're not,
Madam President,
Senator Mark, I hope
no,
you're not,
I apologize
okay.
to you, Madam.
Yes, thank you.
Madam President, I and you go back long, so I apologize to you. Madam, that is my friend. My friend. We fought in Pointe-à-Pitre. Never forget that. And I got licks. I got licks in Pointe-à-Pitre. The president dealt blows. Yes. So I know Skylar. When I'm speaking, I know Skylar, I get licks, Yeah. At the elections, At the elections, Madam President, at the elections, please. Because none of us engage in domestic violence. None. So, Madam President, may I continue? Madam President, I was just drawing to your attention, they were deleting, Madam President, audit or cause to be audit, and they were replacing it with exam or cause to be examined, or cause to be examined. So I was just drawing to your attention, Madam President, that what is the significance, Madam President, of deleting audit or cause to be audited with the words examine or cause to be examined? And I'm just asking, Madam President, what is the mischief that was being addressed here? That's all, Madam President, I was seeking to draw to your attention. So, I do not support, Madam President, the amendment that is being proposed. I think that it is watering down what is being intended in the first instance. So I do not support those changes that the Minister proposed, Madam President. So, Madam President, you go to Section 10, Madam President, of the bill before us today, and it says that no director, officer, or employee of the central bank or person acting under the direction of the central bank shall disclose any information regarding, and it goes on to tell you, but more importantly, it talks about a privately administered pension fund plan and its trustee. Now, Madam President, when I read this section in this bill that is before us, I asked myself immediately whether this section does not clash with the Freedom of Information Act. And this is a matter that we ought to pay some attention to. Madam President, because it does appear to me that there's some conflict in this matter. So I draw this to the attention of this Honorable Senate, so we would be aware of this particular challenge, Madam President. Madam President, we realize that as we go to sections 13 of the legislation, we again see where the central bank is seeking to impose under section 13E, I think B, Madam President, where, for instance, the central bank is saying, or we are giving to the central bank a kind of power in which it can impose, Madam President, any conditions on the registration of the insurer or to give any other directions that it considers to be necessary in relation to the plan. And Madam President, again, these things are very broad. They are very open. And at times, Madam President, we need to make our legislation and the language that we are using a little more certain. Madam President, when you say that the central bank may impose any conditions, Madam President, and this is in the amended legislation that I am referring to, clause 13, and it is amending section 32 of the Parent Act. And this is a provision in the legislation, Madam President. What do we mean, or how are we to interpret the central bank being given the power to impose, Madam President, any conditions on the registration of the insurer or give any other directions that it considers to be necessary in relation to the plan? Again, Madam President, we find that these powers are too broad, they are too wide, they are too sweeping, and we need to have the relevant and necessary checks and balances to this particular section. Madam President, I want to take here quickly because I know my time would be upon me shortly. I go to clause 30 of the bill, and it is on page 24 of my bill that I have before me. But it refers, Madam President, to section 63 of the Act. So, Madam President, again, what it says, in subsection 5, by deleting the word the and substituting the words on the recommendation. Madam President, let's go to section 63. Madam President, I hope you have a copy here. You have to follow. Madam President, you go to 63. Yeah, 63, Madam President. And you go to subsection 5. The current section reads, the minister may by order exempt transfers below a specified threshold from the requirements of section 57 to 63. Now, Madam President, if I were to go through 57 to 63, I will reopen Sagico align this to show you the link between what we are dealing with here and the sellout of our national assets to foreigners by this so-called government, or when I say so-called, you know, they always tell us they are patriotic. They are patriotic. I want the population of Trinidad and Tobago, when we go on a public platform and we begin to tell the country what this government has done, Madam President, they will be anything but patriotic. Madam President, you know what is happening here? Sometimes you can't distinguish between the governor of the central bank and the Minister of Finance. Sometimes I believe the Minister of Finance is the governor. Now, Madam President, certain decisions are being taken. But when it comes to blaming, it's like Shaggy, don't blame me. So, Madam President, what we have in clause 63 is the substitution of section 5. So instead of saying the minister by order exempt transfers below a specified threshold. You know what it is reading now, Madam President? On the recommendation of the central bank, the minister may by order. So it is now the central bank, Madam President, who is proposing to the minister to exempt, Madam President, transfers below a specified threshold from the requirements of sections 57 and 63. So when the time comes, Madam President, and said, it is the Minister of Finance, he said, no, it wasn't me. You see the act, we amended it. This came from the central bank. It is the central bank who recommended to me. So what you want me to do? I had to take the order. So what is happening here, Madam President? Somebody doesn't want to take the blame for this sellout. So poor Governor Dr. Hillier, he's in trouble. Madam President, and you know what is even more important? We don't know what a specified threshold means. What is that? Madam President, what is a specified threshold? Below that, what does that mean? We don't know. What I do know, Madam President, is that the information we have, Madam President, and I stand corrected. Somebody could correct me, Madam President?
Senator Mark, you have 5 more minutes.
Madam President, thank you. I stand corrected. I know that CLICO, before she was taken over by the government, and Madam President, as I'm on this point, I want to ask the Minister of Finance in winding up. Is CLICO solvent today? Is CLICO solvent today? And if CLICO is solvent today, why is the governor under Section 44D of the Central Bank Act not releasing CLICO back to CLICO? Why are you selling CLICO out to Sagico and Align Vest? I asked the Minister of Finance in winding up, Madam President, to answer this question. My information is that CLICO today is solvent, and CLICO today has in its fund close to $3 billion.
Senator Mark, you have very few minutes remaining.
Yes.
And I would ask you
rushing.
to, well, but in rushing, confine yourself to the bill, please.
Madam President, I am eager to come back where you are. Huh? What? I'm coming back, Madam President. Yeah, Madam President, let me just explain something here. Madam President, in 75 of this bill, you have, for instance, under subsection 2, regulation made under subsection 1 shall be subject to a negative resolution of Parliament. Madam President, I want to propose it be an affirmative. Wherever there is negative, I'm proposing a positive or an affirmative so that we can have an eye on this government and what it is doing. Madam President, I just want to say in my closing moments that I have left, I want to read a statement that was in the Express of October 15, 2019. And I read, Madam President, in closing, Sagicor Financial Corporation is paying nothing to CLICO and British American Trinidad to acquire their tradition insurance portfolio worth over $8 billion as a regional insurance company is acquiring insurance liabilities that have a greater value than the total investment assets that are to be transferred to Sagicor. I asked the minister in closing, tell us the total liabilities that Sagicor Alinvest is taking over so that they can get $8 billion without paying a cent for those assets, Madam President. Madam President, I know my time is up. I want to thank you for giving me the opportunity to speak. I needed about 3 more hours to deal with this fiasco that we are dealing with here today, Madam President. But that is for another day. I thank you very much for allowing me to speak.
Senator Deyalsingh.
Thank you, Madam President, for allowing me to speak on this bill, an act to amend the Insurance Act 2018. Madam President, as I looked at this bill, I realized that since 2003, there were major changes that came about, from 2003, looking at the insurance bill then, where there were actually a supervisor of insurance in that post. And that post was abolished by the then Prime Minister, the Honorable, the late Patrick Manning. And actually, the powers was now given to the central bank under the inspector of the, the inspector in the bank. And that power now was transferred to the central bank. And I looked at this transfer from 2003, and I looked at further changes like in 2007, where, it had equities on pension plans, securities, to assist, looking at the statutory fund, which was really the fund left to act as the buffer. Then 2009 again, minor changes was made, and then attempts were actually made in 2011, 2013, 2015, but it really did not materialize. And as the Minister of Finance said, that, finally it came to this conclusion where we could now look at this and debate this bill. Madam President, as I looked at the fact that, the insurance bill, it looks at if you look at the history of insurance, insurance is there really to protect, it was there, in the beginning it started to protect individuals. Shipping agents wanted to protect their ships. They came together as persons, they put their monies together just in case that some ship will sink or pirates will get at one, the others would be able to run their business. So it came about, and it actually, from the marine, the marine safeguards, it went on to property and then personal and life interests and all these things. So there's a great use of it, and we see the Insurance Act actually is important in the sense that, there's the need for insurance in a lot of our transactions. Life insurance, when you're buying mortgage, you need insurance. When you have a car, you need insurance. So it's there. And the importance of that act really is really to ensure that, on one hand, the individuals can have a safety net. But on the other hand, we have looked at the whole purpose of insurance, Madam President. And you remember insurance and the whole portfolio, the whole companies, they are there to actually make a profit. And we must not forget that. And as Senator Mark mentioned, and he spoke about capitalism and the profit margin, and we have to appreciate they are there to make profits, and they would make profits, and sometimes we see that when people go to acquire claims, they may have trouble. And something in this act I'm thinking should be there for the ordinary citizen. There's a financial ombudsman, but there should be something in this where if I'm missing it, the minister will correct me, that where the ordinary citizen can now go and complain, could now somehow reach out and say, listen, I'm having a little disagreement with a company, because we know they are profit driven. And as President Mark said, capitalism seems to drive them. But you see, Madam President, when I looked at the fact that the CLICO scenario happened, and I must say that Mr. Dupré is a brilliant man in the sense that he carried a company, a local company. He was able to move it, go into international markets, go into energy, and we have to admire that sense he had. I think he grew up in St. Joseph. I think he played football with my uncle. He was there. He was a man there. He knew the culture. He knew the country. And he actually took this company to great heights. No one could have foreseen what was going on in the world market, the collapse in the housing industry and whatnot. So therefore, things happened and things started to happen, and we had this situation arising. But, Madam President, as I looked at the fact that, assets of $48 billion, insurance, industry, I mean, it's 27% of the GDP of Trinidad and Tobago. The pension section, 51.1 billion, 31% of the GDP. And, combined assets is 99.1 billion. And more than a third is invested in securities issued by the government of Trinidad and Tobago. So therefore, I want to remind, the fact that, yes, they are insurance companies. They do play an important role in our economy, but they reinvest it in government, bonds. So therefore, if the government has an issue to somehow assist certain companies, we have to make sure it's not a sort of an incestuous relationship where I will, you scratch my back, I will scratch your back, you invest in my bonds, which I need people to invest in my bonds, and if you do need a bailout, I will be there to give you that bailout. So this is one aspect I'm looking at, the fact that the bailouts of certain companies can occur, and we have to, somehow prevent any sort of appearances that the government may be bailing out companies that are taking their bonds and having that sort of relationship. Madam President, I also would like to bring up the fact that if you have the situation occurring with CLICO, this started years ago. It started years ago, and it started under different administrations who actually had to act in cases like this. And I am looking at the fact that if you have this bailout occurring, we have to recognize that these companies, we have to say, if this was allowed to occur, who has to get the blame? Who has to be the one? Is this somehow covered in the Act now that a scenario is going to occur again? Because what I'm looking at is if we looked at the changes from the supervisor of insurance going on to the inspector of insurance, how come the inspector did not pick up, did not alert us, did not alert, the government that, listen, something is going on and we should have looked at the overspending, we should have looked at it. So I am looking at the fact that, yes, we are taking changes that the central bank has given, us to look at, to consider as part of this bill, but it was the same central bank, I think, who was, someone there may have been, in their duty, at their election duty, where they were not alerted or did not alert us in time to prevent this scenario, which caused major problems in the country. And Madam President, I want to say that, when you are looking at the fact that we are looking at even the whole idea of recognizing the blame, once we could get at that point, we have to look at the fact that there's a situation now in the United States when the election is due, and there are allegations that there are somehow collusions between insurance companies and political parties. And you know, I have to say, I want to quote the Time campaign finance. Insurers give big to races determining their regulations. And in this article, it's by Michael Mishak, October 20th, 2016. The insurance industry seeks approval for mega mergers on double-digit rates. It has contributed millions of dollars to sway a dozen state races this year. And following on this article, it says the insurance industry cash is also flowing to campaign for governor and governors. And an insurance industry has pumped more than $6 million in political efforts aimed at these dozen races. And this was according to the Center for Public Integrity, an analysis of the IRS records and data collected by the National Institute of Money in State Politics. Madam President, I am thinking somehow in this act, we should have had some piece of legislation there preventing insurance companies from giving political campaign finance or campaign finance. Somehow in this act, we had the opportunity to put that in. You see, when this whole debacle came about with CLICO, individuals saw the link between...
Senator Deyalsingh, I have to interrupt. I tend to give senators an opportunity to present the context in which they'll make their presentation. So I just need to caution you a little bit. I've given you some time to develop your arguments, but you need to deal with the bill that is at hand, okay?
To elaborate the point, I think both...
Senator Deyalsingh, I actually would like you to not elaborate on the point. I would like you to please try and make your points with reference to the bill and to what the minister indicated as he made his presentation on the bill, okay?
I'm so guided, Madam President. Madam President, as I looked at this bill, I must say also that I must also reflect the sentiments of Senator Mark that the bill was rushed. It was rushed upon us. We had this bill about 2 days ago, and you know, time to prepare for it. It takes a lot out of us, and I'm thinking, why do we have to rush this bill? I mean, is it that the IMF is here, as the Minister of Finance stated, and we needed to get certain things to at least look good in the appearance of the eye of the IMF? And I'm thinking, you know, rushing these important pieces of legislation, which affects the lives of the people, and which could also affect the rest of the country if bailouts occur, and you know, money goes to bailout and not to other elements in society like health, and you know, you find that it can affect, this bill can affect widespread, you know, in society. Because even the bailout, Madam President, I'm saying, I had reservations about that. So I'm looking at the bill, Madam President, and I must say, when I looked at this bill, I have to say that the majority, there were some corrections in the bill. There were things that needed to be corrected, and the minister said he had these corrections that were made. I looked at the fact that that certain sections of these bills, I looked at, and it was simply a matter of clarifying certain meanings. For instance, when I looked at section Clause 6, you know, Clause 6 actually further clarified the control, the meaning of control. Section 11, actually, it looked at the fact that they actually added on shareholder and acquirer of the company, which I think it's something that adds good meaning to this piece of legislation. Section 11, Clause 11, actually tried to amend Section 20 of the Act, Madam President, which clarify, you know, further what is insurance business. It actually clarify business. Instead of leaving business, it actually said carried on insurance business. So all of those are benefits to this piece of legislation. And another issue I looked at this bill is that it had in Section 13, when it looked at it defined who was an insurer, Clause 13, when it amended Section 22 of the Act, it defined who was an insurer, and it actually looked at the fact that it grandfathered in certain individuals who were selling insurance. So certain individuals who may not have the training to sell insurance and who were there. I have retired school principals selling insurance, other persons who are selling insurance, and some people, as I say, go into real estate. So this bill actually took into account that in our economic times, persons may be looking for jobs, and I commend that aspect of that bill also. The other point I wanted to mention, Madam President, was when I looked at Clause 14, and it looked at Section 23, and it actually had a part where you are trying now to look at foreign companies and insist that the foreign companies who may have assets outside of the country would now have to be registered in Trinidad and Tobago. Now I look at this piece and I said that if I'm a foreign company and now I have to be registered in Trinidad and Tobago, we know there's an index, the ease of doing business in Trinidad, and sometimes it's hard to get things and hard to register a business company. It's not that easy. And when you look at the ease of doing business compared to other countries, sometimes to register a company might take longer than it is needed. So even, we are trying to encourage foreign persons to come in and set up insurance companies. We have to look at the other parameters which may deter them. And I think, yes, I see the benefit of having the foreign companies have local registrar. So therefore, if they are locally registered, you can now look at their assets and monitor their assets better and ensure that, I think it's British American, if there's a collapse elsewhere, at least you would have the local revenue to deal with your population. But I'm thinking the benefit is there, yes, to the population, but we have to look at will it deter foreign companies. So we have to look at Clause 15, which I think may also do this. Madam President, I looked at the fact that when I looked at Clause 18, attempting to correct Section 30, to amend Section 30, we actually looked at the fact that the Export-Import Bank of Trinidad and Tobago Limited may carry on business. So we had given an exclusion of the Export-Import Bank of Trinidad and Tobago Limited, and I was trying to find out why this was so. Why should we not simply change the rules of the Export-Import Bank of Trinidad and Tobago and let them just do banking and not be into the insurance, instead of coming and trying to change it and amend it in this piece of legislation? Sure.
No, I think the minister was very clear when he was in his feet that they do have existing insurance clients, and that's why it has to continue until arrangements are made to totally exit the insurance business. Then it needs the flexibility that it now allows them. So remember, they came out of Exico, and Exico really meant export credit insurance. So it's still a feature, and therefore it's very important that that exemption be made for them to allow them to operate both activities, the insurance activity and also the rest of the other activities which are to accommodate manufacturers. So it's very important, and I just wanted to say that to you.
Okay, thank you. So I guess in the future, sometimes they may be so guided where they may just go into one avenue, or they still need to do the both insurance and both. Yes. Okay. Sure. All right. Madam President, I looked at the Clause 21 when it looked at Section 44 of the Act, and the reserve fund, the catastrophe reserve fund. I'm looking at that reserve fund. you could withdraw up to 120%, you could withdraw up to more than 120% net of your premium. And I'm looking at, why that figure? Because somehow along the line I was looking at 150, you're looking at the statutory allowance that you have to reserve, which is now called, why, if it was up to 150 of the assets, why was this, bringing down here this reserve fund? Why not leave it at 150 as it was, we looked at that reserve fund? Yeah. Sure.
Minister, are you asking to say something to... Okay.
Yeah. I looked at clause 25, 26, 27, and it actually helped to clarify certain requirements in the Act about controlling shareholders, significant and shareholders. And that aspect, I think, needed clarification, and it came in at a time when I think it would have helped us from the original Act that we were trying to pass in 2018. Madam President, I want to bring one point here that when I'm looking at the section 55 of the Act, when you looked at that section 55, it was, the fact that you have the ICAT members now being officiated as, people auditors who are actually bona fide auditors, because we have in the past seen certain situations where persons who are not fully qualified being made to sit in judgment of these companies. And I'm thinking this here now would bring into that professional level. And I want to know if, for instance, companies already have a member as an auditor, would they have to now vacate that seat if you're a practicing member in good standing? Will that section now grandfather persons who were already there monitoring other companies? And I want to ask, Madam President, the stamp duties exemption. Why was there a need to bring in that stamp duty exemption? I just wanted a little clarification on that. And I think the Minister would have mentioned the Married Persons Act. We are deleting the words the Married Persons Act, so I just needed a little factor in that. Is it that the clarification, a little more clarification on why we have deleted that word, the Married Person Act, which is in clause 77. So, Madam President, I would like now to just get a few clarification on those issues. And as it goes now, I would sit and await the conclusion of this bill. I think it's long overdue. I think the collapse of CLICO has raised a lot of questions. I think both government and opposition had their, people may have claimed that they had their people or their links within these insurance companies, and I'm thinking somewhere I would have loved to see a level where we can now somehow put in an action there where any insurance companies who may in future want to support any political parties by funding, campaign finance funding, I think something should be put in there to prevent this. I also would like to say that if there is a further dereliction of duty in terms of this is allowed to happen, we have to know squarely who is it to be able to say, listen, you have allowed this to happen. And, I want to just quote one article, Madam President, Clico's Collapse, Poor Corporate Governance. It's an article by Wayne Soverell, University of the West Indies. And in this article, he actually tried to say, what action has the government taken to date? And obviously the government has taken action. What lessons have been learned, and more importantly, how this situation can be prevented from being repeated in the future? And what was the root cause of Clico's collapse? And what corporate governance structures and practices precipitated the collapse? So this article looks at the fact that we would hate for something like this to happen again. And putting this bill in place and having any sort of corrective measures would go a long way into alleviating the fears of persons who are investing. Madam President, I lost money in Clico, but I invested, and I actually invested. I got back some, but the whole idea is you have to look at this whole Insurance Act and bill and put things in place where persons would not feel that level of despair. And as Senator Mark said, persons wouldn't look at these companies as just capitalistic giants or Draculas waiting to just take money out of people's pockets. And as I close, I just want to read one thing, one article in Madam President. The Inequality Breeds Unrest by Rafiq Shah, November the 13th, 2011, where he said, here the inquiry into the collapse of Clico and HU has put into the public domain grave disparities of income distribution. Madam President, looking at that commission of inquiry, we spent millions of dollars. I'm thinking it's time it be made public so I could have made a more informed decision on this bill. And I'm thinking somewhere along the line, if that was public, that Kuhlman's inquiry, I would have been able to say, hey, I could contribute better to this. But as it is, the powers that be has prevented it from being out in the public domain, but I'm thinking as an appeal, we should do that. We've been spending a lot of money in commissions of inquiries, and we are not getting our money's worth out of it. And in this quote from Rafiq Shah's article, he said, when a UA graduate who remains unemployed, and there are many such youngsters, hears about managers making $5 million a month or more by dubious, maybe devious means, how does that person feel? Worse, when the so-called white-collar criminals escape paying for their misdeeds through what complexities of a legal and judicial maze, what message is being sent to the young, qualified, ambitious? I thank you, Madam President.
Senator Obika.
Thank you very much, Madam President. The insurance services sector, as can be gleaned from, not from the length of this debate, which will end, unfortunately, with my contribution, but by its contribution to the gross domestic product of Trinidad and Tobago, is of great importance. It cannot be overstated. The fact that persons, Madam President, submit to the whole notion of a pension fund speaks to the power of insurance in settling the minds of citizens, in settling the hand of companies in their day-to-day transactions, and in stabilizing the very economy that we depend on. So insurance is critically important to our very survival. Now, what this bill seeks to amend through its many clauses is the way in which we function in the insurance services sector. And there are some key issues and questions that arise in my mind. And to me, the most critical issue I face with this is that this bill should have been for the benefit of members present, because I don't believe any of us are qualified in actuarial science. Therefore, it means that no one present today, Madam President, is qualified in any way of their own experience to verify independently, without referring to a secondary authority, that the measures that we are seeking to pass by virtue of this legislation will actually be beneficial to the insurance services sector or disadvantageous to the sector. So that is my first criticism. And because we have in Trinidad and Tobago the Association of Trinidad and Tobago Insurance Companies, who would have in their advocacy regime information, research, and opportunity to inform all of us, I feel that the information that was presented by ATIC, using the acronym, to the Minister of Finance should have by right, Madam President, been submitted to each and every legislator present. So I want to say that the Minister of Finance has dropped the ball in failing to share with us that which his ministry was forearmed with, so that we can make proper decisions for the citizens of Trinidad and Tobago. Notwithstanding that, I was forced to lean on my neighboring profession of finance to provide some level of critical analysis to the legislation that is before us. So, and I want to thank the parliamentary staff for providing me with a physical copy of my speech in case my laptop dies. So, to give an outline of my presentation, the first point would be if we can look at the statutory fund being replaced by capital adequacy. There is no details as to the metrics that will be used to compute the capital adequacy of the insurance companies. Madam President, that is the one string that connects every single clause in this legislation. Because capital adequacy will be the yardstick by which we would measure the integrity of insurance companies and the integrity of the entire insurance sector in this country. And if we as legislators are being asked to allow a change, to endorse a change that was made in 2018 legislation, we should have been apprised of what has been the impact of changes from statutory funds to measuring and monitoring capital adequacy. And I will get to that as I go into my presentation. There's an issue of the FSAP, the Financial Sector Assessment Program. And we'll have questions to ask on that. Then the issue of Exim Bank and its importance in providing confidence to the manufacturing sector and the changes that are made here that impact Exim Bank, the ability of foreign entities to register and do business here, and what are the potential risks where that is concerned, and the government's decision to waive thresholds which are important in enterprise-wide risk management when insurance companies, because of systemic risk issues, fund government's development program. And of course, the point raised by the Minister of Finance about the inspector of financial institutions who has responsibility for insurance companies, not looking beyond fraud in certain circumstances. So to me, those are the key issues based on clauses 11, 14, 22, 31, 38, and 57 of this bill that I would seek to interrogate. The bill has too many clauses, unfortunately, to interrogate all, unless I would be granted the time from the other members of the Senate. But I wouldn't be granted that time, so I could only restrict my contribution to those clauses. Again, I would want to lament that had we in the Senate been provided with the information from ATIC and whoever else, we may have had a better quality in terms of debate. So, I want to go on to the impact on persons. Clause 61, Madam President, seeks to change, it removes the 7-year clause for unclaimed funds. And there's an issue that insurance agents have with that particular clause because it's unclear. It would be opportune for the Minister of Finance to provide some clarity at this time, because if we turn to the explanatory notes on page 11, it says there that it would delete the existing words within 7 years after the maturity date of the policy, and it will now read within the time which proceedings may be taken for the recovery. And when you revert to the Parent Act and that particular section, because there's one section I feel, apart from capital adequacy, that can impact negatively on citizens, policyholders, beneficiaries. For instance, if I were to bring it into the form of an illustration, someone is a beneficiary in a life insurance policy, and they would have claimed the benefit, and the time would have passed. The funds would be reverted to the consolidated fund, I believe, of Central Bank. There is a mechanism in the Parent Act that allows this beneficiary, even after the 7-year period, provided that they can make a good claim through the insurer. The insurer can make a claim to Central Bank that can provide them with the monies. The issue that we face now is not that it's not a 7-year period, but you are simply saying within the time which proceedings may be taken for the recovery. What does that, in essence, mean? Because, Madam President, it raises some serious questions. One question is, how long will this period of recovery take? The other question is, does this have implications for an insurance company who is trying to buy the policies from CLICO, for instance, and there are policies that there are benefits that are not claimed by named beneficiaries, Madam President? Is this an opportunity, or is this an attempt to give those who would wish to acquire the assets of CLICO the opportunity to reduce the reserve that they should hold with Central Bank? That raises a very serious question that if I were to be a conspiracy theorist, Madam President, I would say that there's a sinister plot behind this particular clause. But I am not one, so I only ask the question. So that's a big issue I have with a specific clause in the bill, and I think it is up to the government to provide either clarity through the CPC in reworking that clause, or to give better explanation as to what would be the potential fallout or the potential opportunities for beneficiaries who would be negatively affected to get back monies that are due to them. So I want to go on to the statutory fund, Madam President. Now, when you look at the statutory fund and the movement to capital adequacy, there's an issue here, and I want to quote from the International Association of Insurance Supervisors in a document titled Explanatory Note on the Holistic Framework for Systemic Risk, 14th November 2019. And basically what they are saying in this explanatory note regarding reserves is that supervisors must assess key trends in the sector, investment returns, market volatility, and reserve adequacy. But when you go to see what is their experience in different markets, in how capital adequacy is measured and monitored in insurance companies, it says that stress tests and what-ifs and other rules of thumb are applied where more rigorous actuarial and market-based assessments are required. So for instance, what does that mean, Madam President? Instead of saying, well, our insurance company, we manage $10 billion, and instead of having proper rigor applied to monitoring what would be the appropriate capital adequacy level, they apply their own mechanism. And therefore, if we have 16 insurance companies in Trinidad and Tobago, what we can find is 16 different ad hoc, what-if, and stress tests and rules of thumb, back of the envelope methods of calculating what is the level of capital that is adequate to steer the insurance company to safe waters in times of significant systemic risk. And I'm saying that that is unacceptable, because this is what is the experience, not only in Trinidad and Tobago, internationally. So I think the government should take a second look at providing a better framework for monitoring and measuring the specific risks regarding capital adequacy in the insurance services sector for the insurance companies. Because of course, we wouldn't like to wake up and find one day that inexperienced fund manager applying their own metrics caused significant risk to damage the integrity of the main insurance service providers in our country, especially where, Madam President, we are requiring the insurance companies who sell insurance in this country to have their locally registered subsidiaries in place before they can continue to participate in the economy. So what that means is that we can no longer say, well, Company A is housed, the head office is in Toronto, New York City, or London, and we are comfortable with the rigor that is in place in their home market, and we are comfortable with the rigor that is in place for their subsidiary in Trinidad and Tobago, because there may be some dissonance, because you have a local subsidiary that it may be operating on more laissez-faire regulations regarding capital adequacy. So I'm saying the government should take a second look at that. So, and because we are having this conversation on capital adequacy, we want to say, what are the general considerations? This will be the last point I'll make on this issue. The general considerations will be the insurer's risk profile. The type of insurance that they engage in, whether it be maritime, whether it be life insurance, health insurance, what have you. The regulatory, the economic environment in which the insurer operates. The timing of the projected cash flows of both assets and liabilities. The fungibility, which is the extent to which these resources are easily interchangeable. Now, that's the F-U-N-G-I-B-I-L-I-T-Y. Yeah, I take correction from the minister, fungibility. You learn a new word every day. Today I learned the pronunciation. So, the fungibility, Madam President. So the issue is, we need to ensure that capital adequacy, which is the bedrock of the measurement and monitoring of the ability to withstand risks and significant shocks in the insurance sector, is reflected in the regulations and brought to Parliament so that legislators understand exactly what they are passing. I'll give a simple example as to why, as I move off of capital adequacy. in the merchant banking sector versus the commercial banking sector, you have different reserve levels. So if you are a merchant bank, maybe 9%, 10%, but if you are a commercial bank, the reserve may be higher. I stand to be corrected by persons who would know, by members opposite who would know more than me on that matter. Now, the issue is there's a different reserve requirement regime for merchant banks versus commercial banks. There's a reason for this, and the reason for this is disclosed properly, and it is interrogated, and there's opportunity to interrogate it. What I'm asking for is that same opportunity to interrogate the metrics used for the insurance sector as we move forward with amendments to law. I want to move on to an important point that the Minister of Finance raised, because the Minister of Finance stated that the Financial Sector Assessment Program precipitated the earlier tabling of these amendments in Parliament. And I guess it would be a joint approach between the IMF and the World Bank, with which the IMF is taking the lead. And I want to ask the question, whilst it is important to be consistent with the regime internationally, I think after fulfilling the requirements of the IMF, the government and the Minister of Finance, Madam President, should take the opportunity to return to the Parliament, even if by way of personal explanations, to give or green paper, to give an account of the rollout of the amendments to the Insurance Act. Because, of course, the insurance sector is very important to us. I want to turn to the intermediaries and the requirement, some intermediaries that are not required to register as insurance companies. And whilst that may be consistent with the changes in the law, the issue that I have there is where else would they feature? Because we broaden the catchment for persons who are agents and brokers, added them where there were only sales representatives mentioned in the law. So we're broadening the catchment for persons who are basically interfacing with the public in providing insurance, but we are narrowing the regulation for companies that are involved in the insurance value chain, so to speak. Because, Madam President, when you buy your vehicle, you may not go to an insurance company initially when you get your insurance, because it may be provided to you through your finance provider. The provider, the company providing you with a loan, may have an arrangement with the insurance company. So insurance, the sales aspect of it is tied up so much in the rest of the financial services sector that, in essence, many persons act as agents, as representatives, without that may not necessarily be captured. So many companies should be captured, even if they are not insurance providers themselves, they are not the insurers, they are part of the value chain. I'm saying there should be some way to capture them in the regulations, so that we have best practice across the value chain of the insurance services sector. And I want to turn to Exim Bank. Specifically, the removal of the requirement of Exim Bank to be considered an insurer, even though in our own Minister of Finance's piloting of the bill, he made it clear that insurance was a key part of their business initially. And it may not necessarily be so going forward. But I want to ask the question, is it that we are saying that we can't envisage the potential for an export-import bank to be providing insurance in the future? For example, credit insurance, export credit insurance, which basically provides the confidence of the manufacturers to enter new markets. using the accounts receivables. So basically, some companies want to buy steel pans, for example, from Trinidad and Tobago, and they are based in Dubai. And Exim Bank would facilitate, possibly. The issue I'm saying in this hypothetical example would be, should the persons at Exim Bank, the leadership at Exim Bank, desire going forward in their product mix to be involved in insurance in a more robust way as Trinidad and Tobago manufacturers go into newer markets, as we go into the African markets, as we go into the markets on the Indian subcontinent. These markets that are significant in the Middle East and the Far East, as we go into these new markets where there may be a greater need for export protection for your receivables, are we saying that we can't see the potential for the Export-Import Bank to be heavily involved in export credit insurance, as is done with the Export-Import Bank of the United States? So that's a question that I want to ask, and I'm saying, I'm basically making an appeal that it may not be the best time to remove that from the Export-Import Bank and keep it there, even if it may simply be as a precaution in the event that they wish to go. So what you're doing is you're not constricting the business model of the Export-Import Bank of Trinidad and Tobago, and you're giving them the opportunity, a road reserve, as we might say, when you're constructing a highway, to use it if they feel to, Give them that opportunity. Now, there was another issue regarding this bill that has to do with making the assertion that once foreign companies, operate in Trinidad and Tobago, there may be a better opportunity for them to comply with the regulations and may protect the policyholders and beneficiaries in the country. I want to say that however we do that, we should be careful to ensure that we consider all the possible risks. For example, when a company operates here and its books are separated as in such a way, it may mean that policyholders, beneficiaries here may not have recourse to the bigger books of the parent company. So in essence, here operates as a cash machine for that company, more or less to harvest the savings of citizens and repatriate the profits. So in doing that, we should be careful to ensure that policyholders and beneficiaries may not be cut off from the extensive savings of these international insurance companies that may be housed in a different jurisdiction. I want also, when they are contemplating that the regime for that, to get proper advice on issues of translation of earnings, transfer pricing, because the cost model.
Senator Obika, you have 5 more minutes.
Okay, thank you. Time went fast. So, to consider the cost model, because international companies tend to have a tendency to front load the costs, significantly overweigh the costs from head office in the operating expenses for the subsidiary in Trinidad and Tobago. We don't want to fall prey to that routine international business tactic. Now, Clause 38, Madam President, to me is the most dangerous clause in the way in which it was articulated. For the government to continue to borrow to fund the development program, unless this new chamber has made it difficult for me to understand the minister well, what I understand is happening there is that it's tantamount to the government waiving the requirement for the insurance companies to conform to best practice in terms of enterprise-wide risk management, so that they can simply lend the government, and they give them a 5-year hiatus, a 5-year window.
Senator Obika, my apologies. You have much more time. Yes. So you can continue, and I will give you the 5-minute warning accordingly.
Okay. Madam President, can you tell me what time I am required to finish? Or how much more time I have?
Sorry. At 33 minutes past 4.
Okay. All right, thank you. So I will double back a little bit.
Okay. Try and use the extra time wisely, Senator Obika.
Because I really wanted to talk about the anyway. So let's speak specifically to this. Because, Madam President, last year, the government, and I'm watching a trend, the government increased treasury bills to 5 billion, to 7 billion. The government increased the overdraft to 20% of revenue. The government significantly increased the level of exposure that banks can put on their books to the government of Trinidad and Tobago. And now, Madam President, through the seemingly innocuous measures in this bill, we are seeing in Clause 38, the government seeking to even borrow significantly more without even a limit in a 5-year window from insurance companies and pension funds. And Madam President, the entire savings of a nation rests peacefully, soberly, and prudently in these very pension funds. Madam President, I want to submit that this is the most reckless amendment I have been privy to in my entire time here in the Senate. And I feel that the government should remove this amendment entirely from this bill. If I were to take the words of the Minister of Finance, that this will allow the insurance companies to fund the government's development program after raising the treasury bill limit to 7 billion, the overdraft to 20% of revenue, and significantly increasing the exposure that commercial banks can put on their books to the government of Trinidad and Tobago. Why not? Why would you all, and borrowing more from the Andina Development Bank, maxing the amount required based on the agreement? How much more can you be willing to borrow for development program? How much more? What this is doing, Madam President, this is a reversal of savings. This clause, 38, is the reversal of savings clause, because insurance and pension, the pension funds, represent the savings of our nation. It is from your savings as a nation that you measure risk. I will give an example of what that means. An individual and a family who has attained significant levels of savings can do much more, can plan for a more longer-term development program as a family than one who has depleted or limited savings, or savings that the majority of it is encumbered by debt. What the government is seeking to do, Madam President, through this clause, is to surreptitiously, to quietly increase significantly the debt of the citizens of Trinidad and Tobago. Madam President, the government must remove this clause. And there was another serious clause I heard the explanation for which the Minister of Finance articulated, and that had to do with clause 57. And I'm not sure if I heard the minister right, so I want to repeat what I interpreted the minister to say. I'm paraphrasing now, and if I am incorrect, the Honourable Minister can let me know if I'm on the right path or the wrong path. The minister in clause 57 thereabout was saying that the inspector can only send compliance directions regarding fraud. And I want to ask the question, where else can they, on completing an audit and conducting an audit? So if, I'm asking the question, if maybe it may be covered in another clause, but I'm asking the question, in conducting an audit, can the inspector provide directions for issues of drug trafficking, human trafficking, explaining your wealth issues, misappropriation of state funds, misconduct in public office, theft, extortion? The question I want answered is, where can we find those, if not here? And if we are circumscribing the inspector simply to matters pertaining to fraud, why not these other matters, if it's not included somewhere else for the public's edification? So, Madam President, there were some other issues regarding this. And I want to say the statutory fund had a mechanism of one-to-one, basically, assets to liabilities. What exactly would be the mechanism for the capital adequacy? I would like the Honourable Minister to submit as well what were the specific conditions, notwithstanding the amendments that are in front of us. What were the specific conditions of the IMF in the Financial Sector Assistance Assessment Program? What are the specific conditions that he is required to fulfill, so that in looking at the amendments to the legislation, we could determine which are superfluous and which are necessary? We need to know that information. Madam President, the Minister of Finance, this is part of public record, made an assertion that nearly $100 billion, TT dollars, represents the combined assets of the insurance and pension sector. Nearly 100 billion, 99.1 billion. And the minister said that just more than one-third of that, so over $33 billion, accrues to the government of Trinidad and Tobago. I want to ask the minister the question. Since we are being asked to approve Clause 38, if the government finds it difficult to walk away from that clause that allows them to increase our indebtedness, to borrow more on the pension funds of the country to support development program, I want the Honourable Minister to indicate what percent of this 99.1 billion, because we are 33% now, that the government, that is due to the government, what percent of this 99 billion is the target threshold that this clause will facilitate? What percent of it? Would it be 50%? Would it be 40%? Because I am sure we would not be making such amendments in a vacuum. There must be some metric that guides it.
Senator Obika, you now really have 5 minutes left.
Thank you, Madam President. So, Madam President, no, this I looked at the aim of harmonizing the Insurance Act with the Financial Institutions Act. And there was an issue with speaking to control and treatment of credit exposure. And because I would have liked to see in the explanatory notes, there was some mention made of capital adequacy and solvency requirements and credit exposures. I would like if the Honourable Minister could indicate what would be the specific treatment for mortgage-backed securities, because they are and credit exposures in the local context and international context. Because just as you could have threshold standard for government exposure, what would be the thresholds for these types of derivatives, which are becoming more popular in our domestic market as developers find creative ways to get funding, low-cost funding, which you get from a mortgage-backed savings instrument? What would be the thresholds that would be applied to companies in the financial service sector, pension fund managers and so on, in engaging in these types of securities? Because many trade unions and insurance and credit unions and banks target this aspect, especially when they try to build homes for the members. What would be the threshold limits so that we can advise treasury managers and risk managers in financial institutions? And on a closing note, Madam President, I would like the Honourable Minister to indicate specifically what has been the experience with the Catastrophe Reserve Fund domestically, given that we don't have any information from the Association of Trinidad and Tobago Insurance Companies. So in conclusion, insurance is important to us as a country. The clauses in this bill will cause significant changes to the insurance landscape in the country, and there are significant risks that need to be mitigated against, the most grave of which would be government's exposure and the sector's exposure to government, because that will significantly impact how they are assessed internationally and how our economy, the integrity of our economy going forward. I thank you, Madam President.
Honourable Senators, the suspension will now take place and we will return at 1 minute past 5.